is a live, copyrighted presentation. Ladies and gentlemen, it's time now for RadioLawTalk.com with your host, Frederick Penny, attorney at law. And now, RadioLawTalk.com.
Hour number 2 of the most entertaining radio show in the United States, Radio Law Talk. This is your host, Frederick Penny, Denise Dirks, Chris Rodriguez. We've got Daniel Griffin here. We've got our illustrious producer behind the glass, Cal Hunter, Seth Madden, our call screener, Brad Smith, welcome, our co-producer today, and Todd Cunin is off today modeling and being on a commercial. He is greedy. I don't like him. He wants money, so he actually goes off and does some commercial instead of being here and getting paid the high dollars we get paid.
Heaven help whatever product it is that he
Oh my gosh. Who would hire him in order to, and he gets paid. You know what, is it cat litter?
It can't be much.
It's got to be a cat litter.
He can't be getting paid much.
He did take his cats on the shoot, I've been told.
Oh, has he? Did he really? I believe Cal, because that's Todd.
Hey, more likely than taking his girlfriend to the shoot, right?
That's exactly
What girlfriend would that be?
That assumes facts. Objection assumes facts.
not in evidence.
Exactly.
That's exactly right. So, Todd, yeah, he is looking for a girlfriend, correct, Denise? And you are in charge of finding him a girlfriend.
Well, I've tried, and he has nixed that idea.
So
He'd rather stay at home with his cats.
Hour 2, Denise, if they want to call in, especially from the Amorosa Valley, where do you call and how do you get in touch with us?
You call us at 855-LAW-RADIO. That's 855-529-7234. Or tweet us at Radio Law Talk.
If you can call in from the Amorosa Valley,
Amargosa.
Amorosa is the Trump's friend from
Exactly.
yeah.
Did I say something wrong again?
Probably, but I said
Amargosa.
Yeah.
Did you
Yeah.
say Amorosa too?
Yeah.
Oh,
If
Amargosa.
you call in from the Amargosa Valley, I will send you a $20 bill and a signed Radio Law Talk mug, but you do have to provide an address to where I can send the check. Okay?
And P.O. boxes don't work?
No P.O. box, no.
And no pet squirrels.
I tell you, I'm going to go there someday, and I'm going to take a picture. If I'm ever in Nevada, next time I'm going to go drive to that valley. I'm going to take a picture, and I'm going to tweet it out.
Hey, you go there every year when you go to Burning Man. You
Oh,
go
that's
right
true.
by
Yeah,
there.
you're right. That's exactly right. My Burning Man experience.
Your family is going to be so happy when you say, "Hey, it's time for our family vacation this year. Where are we going? Maui? Are we going to Fiji? No, Amargosa Valley.
Amargosa
This year.
Valley, and we're going to go to probably the casino. I think, hopefully, the casino turns our radio station on. But we were talking the first hour about the lawsuit that Monica Seles' husband brought against his designer for his former yacht. And wait, listen, this is Monica Seles. This is her playing tennis.
This is what she's famous for.
Louder.
They wouldn't let us mic her up. We had to take it from a distance. But
She's playing tennis. It sounds like the scene from what's the movie with?
I don't know. Todd would know.
Yeah.
That's titillating, you guys.
Oh, it is.
What did she just say?
Titillating.
It's my synonym for interesting.
Oh, my gosh. Cal, is our insurance up to date?
well, it'll be titillating to find out.
Oh, my gosh. We got to talk important things about Monica Seles' the lawsuit. So Seth tweeted out a picture of this yacht. It's gorgeous. For $547,000, we can... you can charter it for a week, and the hourly the designer was charging 140 hours. They're claiming she's supposed to charge $140 an hour, and her cost for whatever, like the cushions, the
Yeah, the
pillows.
actual-
The fake plants.
Yeah, the fake
The innovations.
plants, whatever. Because obviously she wasn't in charge of, retrofitting the engines, but apparently it was about $800,000 was her bill, and he said she overcharged them. But all I got to say is for $800,000, I will help him design his next yacht.
So I mean, what are the legal issues on this type of a thing?
Bring that up. Because don't
So-
forget, tell him what type of contract it was.
Well, so apparently there was an oral contract.
That's right.
Which you can sue on an oral contract, but you have to prove what the terms were, right? So,
That's right.
apparently there was an agreement to pay this designer $140 an hour.
Right.
That's a pretty simple oral agreement, and it would be interesting or titillating, or whatever word you want to use, to see what Monica Seles' husband said the agreement was.
Well, this is what he said. He said that it was the $140 an hour plus expenses, and anything she bought for the yacht was at her cost, but she was upcharging it, he said, up to $300,000. So if the couch was $3,000, she charged him, as an example, $3,500. And that's what he said was the upcharge, and he's suing her for it.
So he's saying that he didn't agree to
co-
pay an upcharge on the materials
That's
that she
exactly
purchased.
right.
No,
But it's very-
no markup. No markup.
But it's very common when she goes out and she's looking for these things. It's very common that there is some kind of a charge. So that might be an industry standard.
Absolutely.
But think about it. She's being charged $140 an hour to be walking around and picking this stuff out. So is that a double charge? But here's what Chris is making the point, I think, here that people have to understand that are listening to Radio Law Talk is you can have a contract, and Daniel, you're shaking your head yes, too. You can have a contract. I've heard people say, oh, I don't have a contract. I didn't have it in writing. No, a contract is completely valid if it's oral. But the problem is, like Daniel, we're going to talk a little bit about bankruptcy in a minute, is it's just tougher to prove.
Absolutely.
Yeah,
Absolutely.
yeah, tougher to prove.
And there's some contracts you can't have that are not in writing. You
That's
have like
true.
a statute of fraud problem.
Right, there are, and
Like
especially
real property, absolutely.
And not only that, actually, technically, if you have a contract as a client and a lawyer, you're supposed to have it in writing too.
Yeah, we've learned that from Johnny Depp.
That's exactly right. That's the Johnny Depp case. So you have to have that. So anyway, that's the Monica Seles.
But
thing.
let's also talk about. I, as a lawyer, already don't like Monica Seles' husband. What do you think the jury in that case is going to think of Monica Seles' husband? This is a guy who charges out
Cheap.
$540,000 a weekend, but he's saying that the designer that he hired at the very reasonable rate of $140 an hour, he doesn't want to pay $300,000 in upcharges to. That's less than what it rents out for a weekend.
So
this guy sucks. I wouldn't want to take that case to.
Tell me how you really feel, Chris.
I wouldn't want to take that case to trial. I mean, you find me 12 people that are going to like that guy.
And I agree, but maybe the designer's probably. I'll put money on it. The designer's not hurting either. She's driving a new Bentley or a new Ferrari,
Well,
a
he
Toyota
might-
Ferrari.
He might force her into bankruptcy. Who knows?
That's true. Let's talk about bankruptcy. So
Yeah.
let's talk about bankruptcy. We've got 3 important bankruptcies to talk about. Those of you out there that want to call in about bankruptcy, call 855-LAW-RADIO or tweet us. Bankruptcy is a really important thing to understand. First of all, Daniel, everyone thinks it's such a bad thing. Not necessarily. Sometimes it's something you have to do to help yourself out. So Daniel's going to explain, and that's what he does. He does bankruptcy law. A little bit about bankruptcy, how it's not just a state court issue, which a lot of people think, oh, it's in the state. And then we're going to talk about 3 specific cases he's going to talk about. The Peabody case, the Toys R Us case, and the Dairy Queen case.
Hey, I've got to say, Kenneth Konecki, he has shown us a picture of your C-Rod's Ferrari. So we have to
let's
look
see.
at that.
Oh,
Wait a minute. Oh. Oh, yeah. Nice.
Oh, I got to show that to our YouTube fan. Basically, that is what is that?
A little
wagon.
red wagon.
A
A little
wagon.
red wagon.
Well, go to Radio Law
Very
Talk
funny.
Twitter.
Very
Thank
funny.
you for that.
I
That's
bet you he's
great.
from the Amargosa Valley and he's ticked right now. And he's sending you a picture of that. He's sending you a picture of that. So, but anyway, we're going to talk about that. Those 3 main businesses. We're at the top of where we're almost at a break, so we don't want to cut Daniel off.
I want to learn what bankruptcy is, so I'm hoping that Daniel, after the break, before we get into those cases, will tell us kind of just the basics of what the system is and how it works.
Stick with us. We're going to talk about bankruptcy.
Now back to RadioLawTalk.com.
I used to bite my tongue.
tongue and hold my breath. Scared to rock the boat.
Hey, we're back talking to attorney Daniel Griffin about bankruptcy, especially about the Toys R Us, the Dairy Queen bankruptcy, the Peabody. Tell the listeners, Daniel, a little bit about the basics of bankruptcy and why you file it, how can you file it, the different type of chapters and what they are. So why don't we just roll that in, just so they understand what's going on, first of all.
Sure, the basics, the foundations, other synonyms I can throw out there. Let's
Titillating.
the titillating parts of bankruptcy.
Nobody has ever called bankruptcy titillating.
I am calling bankruptcy titillating.
Okay, well, we'll see. We'll see.
So you got the main players, and it kind of helps to start there. You have the main person who owes all the debt, the debtor. They're the one who files. You have the creditors, all the people who are owed the money. We break them into two parts because we treat them very differently. You have secured creditors and unsecured. Unsecured are the ones that you're basically telling to go jump in a lake. You're going to get discharged. You can't collect anymore.
They're last in line.
They are last in line. Okay. Secured creditors are protected by their interest in property. They have a lien against some property.
And it can be personal property.
It can be personal property. It can be real property.
Or they can do like what's called an SEC filing, or filing like an equipment. Can't they do a filing?
Yes.
UCC, sorry,
yes.
not SEC.
UCC.
Yes, so the UCC filings against fixtures or equipment. You're exactly right.
Right.
Then we have executory contractors.
Stop right there. I got to interrupt you. SEC, I'm thinking football already.
Security and Exchange.
No. I believe me. They had nothing to do with the Security Exchange Commissions. It was all SEC football. I'm thinking about football games today. So go ahead.
I remember you did that before, and I was confused for like 40 minutes. I couldn't figure out which SEC you were talking about.
I'm talking about the football.
That would be good for Ezekiel later, though.
There you go.
Absolutely. Absolutely.
Go ahead.
Then we get into some of the contracts, like executory contracts. That's like leases where someone's renting out property. Those are treated differently. Then big player, obviously, you have the bankruptcy court. They're the ones that are kind of checking everything, making sure everything's fair, everything's equitable. You have the U.S. Trustee's Office, a department of the Department of Justice.
They're
providing
federal
some
courts.
oversight. They are federal. And so they're providing some oversight, making sure everything just moves along smoothly. Then you'll have a trustee. People who are familiar with estate planning will know a trustee is someone, a third party, looking over all the assets of the estate.
And do they get paid by the government? How do the trustees, they get paid by the government to oversee this? Like a bankruptcy? What do they do? I don't know how that
is
works.
the fun part. Depends on the type of bankruptcy. And we'll get right into that. So
Good.
Let's back up one step further, though.
Sure.
So if I'm an individual or I'm a company and I cannot pay my debts as they become due, that's when I may file a bankruptcy petition in order to get some sort of protection from the bankruptcy court, correct?
So there's levels. You're exactly right. If you're having trouble, there's a level of bankruptcy for you. You make a repayment plan, which is getting into the businesses. If you absolutely cannot pay everything back, you go into a liquidation. That's a 7. We'll talk about that more in a second. Chapter 7, absolutely.
Yeah, individuals have Chapter 7, Chapter 13 as options, and the 13 is a reorganization of the debt so that they can pay it over time.
Yeah, it's called a wage earner's plan. Basically, if you can make payment plans, you just got to reduce a little bit or you got to stretch it out a little bit. That would be a 13. Absolutely.
And then usually the big businesses, when they file, they go for a Chapter 11.
Chapter 11.
And that's always a reorganization.
That is actually titled a reorganization under bankruptcy law. And what we're going for there is it's a multi-step process. Won't go into the nitty-gritty, but the general idea is you're trying to get creditors to agree and to vote on a plan for certain treatment. You can reduce or increase their interest payments. You can reduce or increase the principal owed. You can reduce or so on and so forth. Certain creditors you treat differently. But the general idea is for businesses, the main thing that you usually see is that they go after those executory contracts.
Whoa, what's that?
Executory contract is a contract that has not been fully performed yet.
Exactly. And so the big thing that comes up, and actually one of the things that came up for Toys R Us, for Peabody, is the leases they have for all the real properties. So when they have, a manufacturing company, well, I don't like the terms of the lease anymore, so guess what? In bankruptcy land, we get to either assume it or reject it.
Nice.
That's it. And so that's where a lot of the overhead gets cut out. And so you have these companies that are over their head and they're trying to make these payments and get ahead and get back on track, but they can't because they're committed to these contracts. The Chapter 11 plan lets them just cut out the ones they don't like in the underperforming locations, sell everything off, start over, and reduce the overhead.
Now, I understand that the Toys R Us is the third largest reorganization in U.S. history. The first largest one was Kmart. Believe it or not, they were
Is
trying.
Kmart still even around?
No, but they had a $14 billion debt obligation. And then 1990 Federated Department Stores, also known as Macy's, had $7.9 billion.
Cal, what's that?
Kmart's owned by Sears now, which
I
is
didn't
having
know that.
its own trouble.
Oh, I know they are.
Yeah.
That's exactly right.
Can I ask a question? So is it the case then, and I know just from doing litigation that there are a lot of businesses that are still doing well, but they choose to go into bankruptcy, and I think you're touching on that a little bit. Is there any kind of a requirement that there be some sort of financial distress before you go into bankruptcy, or is there a legal? Do big companies have legal people that just look and try to see, can we take advantage of bankruptcy today? No. Can we take advantage of bankruptcy today? And if there's a reason to do it, even though they're going like gangbusters and making all kinds of money, they go into bankruptcy anyway to get rid of some leases or do even better. How does that work?
That is a fantastic question. It gets into the pre-petition strategy. What you're generally looking for is if you can justify it to a third party. So I can't just today start a business and go, you know what, bankruptcy time. I'm just going to eliminate all my debt. It's really geared towards change in market conditions, which happened with Toys R Us. It also happened with Peabody is a great example of that. They're actually a success story after Chapter 11. I think their stock prices are actually going up these days because of the result of their bankruptcy and reducing their debt. But it really comes down to looking at the bigger financial picture. How are they doing? If they're doing great, you're probably not going to want to file a bankruptcy because you're giving power over to other parties to negotiate hard. And if they don't like the types of arguments you're making, and the bankruptcy court kind of takes a little bit of a harder look, they may put all your property into the hands of a third party, a Chapter 11 trustee, which we can get into another time.
Because sometimes in Chapter 11, the debtors can act as their own trustee.
As a debtor in possession, correct.
Right. But other times, if there's some doubt about their veracity or something to that effect, then they're going to have a trustee that's going to be paid for and appointed.
Who takes over the case, exactly.
And the assets.
And they're in charge of that. So like you said, Daniel, the problem is you put someone else in charge of your business.
Yeah.
Absolutely.
And so there's and we're coming up to the break, but generally also the important thing to note that I'm going to have you talk about when we come back is there's a certain amount of time that you can file it. Like every 7 years, a personal bankruptcy, you can't just constantly file them.
True.
During certain time periods. We're going to be right back talking about bankruptcy with Daniel Griffin, attorney.
Hey, tweet us at Radio Law Talk.
You're listening to RadioLawTalk.com. And now back to your host, Frederick Penny.
We're back putting Amargosa Valley on the map. That's what we're doing here.
Absolutely. If you live in Amargosa Valley, I will pay you $20 cash money along with a signed Radio Law Talk mug. All you have to do is call in.
855 Law Radio. That's
all you have to do. Somebody wake up in the Amargosa Valley, please.
And that is very titillating.
It is. $20 cash is always titillating.
Especially with the casino there. I mean, think of it. You could take Chris's 20 and you could be Amargosa Valley's next millionaire just with Chris's $20.
Absolutely.
Hey, okay.
Hey, we have a program where we have law students that do research for us, and the research done on the bankruptcy Toys R Us issue was done by Sydney Colbert. She is from University of San Diego School of Law. She did this for us a couple weeks ago. We didn't get to it, so I just wanted to shout out to her. Thanks a lot for your help.
Hey, Brad, our assistant over there, our new co-producer. Can you hear me in there, Brad? Raise your hand. Brad, I want you to get on the phone and call the casino in the Amargosa Valley and say, this is Brad from Radio Law Talk. We are streaming live in Amargosa Valley. Do you have a radio station there? And if not, can you put us up on the radio?
Okay, hold on. As a lawyer, I do want to say that would void my promotion here because it would be a breach of the covenant of good faith and fair dealing. We all understood that we want to see if anybody is alive and listening in Amargosa Valley. We can't have a co-producer go out and call somebody and say, hey, let's make $20.
Well, wait a minute. Seth's still here. He can do it.
There's an important note here. The casino at Amargosa Valley is also an RV resort.
There you go. There you go. Seth, call him. Call the RV resort. I want to know. And you know what? I'll kick in 10 of the 20. But we'll still say it's 20, but you only have to kick in 10.
But what is the RV resort? Does that mean like you're staying in an RV, or you like the casino is an RV? When you open the thing to go in the casino, the steps come out, or how does that work?
I think the casino isn't actually a trailer. And then the people live in the RVs when they come to the casino.
Got it.
That's the hotel room.
Okay, I got it.
Let me tell you right now, we are putting Amargosa Valley on the map, and it's going to happen. Go buy property there now. Because you know what? It's going to be the value of that property is going to quadruple because Radio Law Talk is so well known.
Either that or we're pissing off everybody in the Amargosa Valley.
Nope.
Irritating.
They like us. No.
Okay.
No, they like us.
They're probably all going to go and look up their right to file bankruptcy.
That's a titillating word. So let's get back and talk about. Let's get back and talk about the important thing. Seth's trying to call him. He's like hanging up, like I don't know. There's nobody answering.
They got an answering machine. This is the Long Street RV Resort. We're out cleaning the slots. Leave a message.
Or we're out listening to Radio Law Talk and getting in our trucks driving down here to beat Chris Rodriguez up. So let's talk about bankruptcy. We're still talking about bankruptcy. Let's go back, and we're talking about the difference between Chapter 11 and Chapter 7's personal bankruptcy. And you're kind of laying the foundation for us, so keep going.
Sure. So getting into kind of the types there, I mean, the type you want depends on the benefit you want. The big benefits of bankruptcy are, first and foremost, you get the automatic stay. And that gives you breathing room to kind of figure out what you want to do.
So what automatic stay is that people cannot bring actions against you. They can't serve you with process. It protects the debtor from other litigation.
Puts everything in neutral.
Yes.
Absolutely. Prevents communication from all your creditors. So if you owe money between a family, sometimes that can get kind of a bit of a thin line in terms of whether you're violating the stay or not. When you say, hey, I know you filed bankruptcy, but you still owe me $20.
At Thanksgiving, right?
Absolutely.
Pass the turkey and a $20 bill. I'm from Amargosa Valley. You owe it to me. Rodriguez.
But it also prevents a lot of things. The most common things we hear about is like wage garnishment, foreclosures, judicial proceedings, debt collectors. That's what you're stopping there.
Right.
Another big benefit is, like we talked about at the beginning, is you get to assume or reject those contracts. So if you're in a lease and you don't want to be in it anymore, you can assume or reject those leases.
And the nice thing about that, not to interrupt you again,
Sure.
but it's a lot of times you can negotiate stuff.
Right.
Yes, absolutely. You can redefine the terms. That's a fantastic use.
Yeah.
But then the final thing, the big thing that bankruptcy is really known for is the discharge. And what you're doing is you're taking that underlying debt. You owe someone $100,000 and it's unsecured. No property is securing this debt. You are now making that debt uncollectible through judicial action. There's actually a lot of really interesting documentaries about what happens with that debt afterwards, and the market has accommodated to sell off that debt to try to collect it anyways. Side point. But what you're doing through bankruptcy is you're saying you cannot collect this through the courts anymore.
And
that's
it's
what
a
people are
fresh
going
start.
for.
It gives a person a fresh start. That's the idea behind bankruptcy, is really that many, many debtors out there, they may have medical debts, they may have all these different types of debts, and it just allows for them to have a fresh start. And one thing that's interesting for me in bankruptcy is claims of exemption. I mean, I really like the idea that if I own my house, I have a homestead exemption in my house. And how I claim my exemptions in bankruptcy allows me to protect some of my jewelry, or protect my vehicle, or protect my home. And the timing of bankruptcy becomes super important too, because if, let's say that a creditor comes after you, gets a judgment, and secure against your home, and then you file for bankruptcy within 3 months, that debt could become unsecured, and that creditor could be treated as an unsecured creditor.
And you discharge the entire debt. You're exactly right. That's one of the fun parts of the strategy, is figuring out the timing of everything.
Right.
But you're exactly right. And California is kind of interesting. Some states will only allow you to choose between federal and one set of exemptions on the state level. California, there's actually two. There's 703 and 704 exemptions, and you're exactly right. Under 704, there's that homestead exemption.
Right.
Usually when people have a home and they have equity in the home, that's what they default to, because you protect up to about $75,000 to $100,000 in the home's equity. If you have more cars, cash, something along those lines, you would go for 703, and you use mainly
That's
what's
the
called the
swing.
wild card. Yeah,
That's the wild card or swing exemption, because then you can protect the value of things, and it's not necessarily just a certain type of asset.
exactly. There's a lot more flexibility there. The homestead, it's your home, but the wild card over in the other set of exemptions, that's where you get to choose what to protect, and you can have a lot lot more creativity in that.
So let's talk about Peabody, because I think Peabody was a really interesting Chapter 11 reorganization and a successful one.
Absolutely. Like you just said, it was one of the success stories. It was originally filed over in the Eastern District of Missouri. One of the fun things about Chapter 11 bankruptcies, is, especially the bigger corporations, is just seeing the sheer amount of cases that have to be administered. This was 100 cases that were all jointly administered. I lost track at about 100. You have adversary proceedings, which are litigation proceedings trying to determine what type of, what debt is dischargeable or not. But really, getting into the background of this story, you are looking at a coal company. And this was the result of declining U.S. interest in coal industry, and that was just looking at it
still
broadly.
kind of happening. Yeah,
it's still happening as a market trend.
Right.
There's some regulatory pullbacks in U.S. policy, but generally the U.S. was moving away from coal and still is as a market.
And that's a lot to do with climate change and our resources and the atmosphere, right?
Absolutely. Investment in new sources of energy. And so Peabody was on the other end of that. They were a long-standing coal mining company. But they went through the whole Chapter 11 process, and they, as we said, they got to the success story. The effect of their bankruptcy, it says, was to slash about $5 to $6 billion of debt through the process, renegotiating, rejecting leases, getting all these creditors to agree to a new plan. So what happened as a general idea, and just so you know how complicated this gets, you first got to disclose to all the creditors and all the investors. That disclosure statement that you're trying to get people to buy into your plan is 319 pages long. And that has information on what happened, where you're going, what's happening now, all the finances, the executives, their compensation. And the fun part is that it really tells the story of the bankruptcy debtor, and some of the fun things that come up is it tells the woeful story of all these executives over in Peabody, and their task has been insurmountable, but somehow they battled the odds, and that always comes up in the disclosure statement. Once you get all the creditors to buy in, though, you got to amend it a couple times, make sure they buy into the story. Once they buy into the story, you get a plan, you get your new contract. That has to be confirmed either with all the creditors agreeing, or you do what's called a cram down procedure. If one creditor out of the hundreds, thousands maybe creditors, if one of them disagrees and rejects the plan has to be crammed down or it's not accepted.
I know there's a lot of people who are out there, and this is extremely informative, but I have a feeling that the people in Amargosa Valley, they just fell asleep. They were going to call in, but they fell asleep. We gotta do something. What I propose to Fred here is, when we're talking about bankruptcy, Fred and I should take our shirts off just to kind of liven it up a little. Like you're eating like chicken soup for dinner. You gotta do something to spice it up a little bit. So maybe when you're talking about bankruptcy and you and Denise and are educating our audience on that topic, Fred and I will be shirtless. So that we can.
No. I've just lost weight and everything's hanging right now. So remember,
no baby oil for the YouTube channel.
Remember, yeah. Luckily, we've got 15 seconds left, and we're going to come back and we're going to call some businesses in the Amargosa Valley, and we don't care what businesses they are, and we're going to see if they're listening to us. We'll be right back with Radio Law Talk, trying to get a hold of Amargosa Valley.
Radio Law Talk. I like that show.
Yep, you're listening to Radio Law Talk, even in the Amargosa Valley of Nevada. RadioLawTalk.com.
Trying to get in touch with anybody at the Amargosa Valley, and we have called a few different businesses, and we're going to keep working on that.
Answering machine at the sheriff's office, by the way, but I'm still trying.
Yeah, we're still trying, but you know what? I want Rodriguez's $20 gone. I want that $20 gone.
At this point, so do I.
That's exactly. And not only that, I want to get a Radio Law Talk mug to the Amargosa Valley. So that's
we should send a complimentary, whether they call or not, Radio Law Talk mug to the Alien Cat House, Area 51 Alien Cat House in the Amargosa Valley.
Okay.
I think that is, it's been voted Business of the Year, I believe.
Well, it's Todd Coonan's favorite place.
Yes, it absolutely is. So Google that.
Do they have
and
cats there?
we should send that.
Cat house.
Oh, it's
What
a
would
cat
they
house.
have?
There you go. You're right.
What else would they have?
Man,
Where
over
the
my
cats
head.
are out of this world.
That's exactly right. Oh my gosh. What we're going to do with that, I tell you, the Amargosa Valley's business is going to pick up 20-fold. So we were talking about bankruptcy. We had to get off and talk about something else.
Yeah, I wanted to talk about Peabody just for a second because there was 3 coastal California communities that were suing fossil fuel companies, one of which was Peabody, over their role in climate change. And so once that happened, once they sued it, it ended up getting transferred to the bankruptcy court. And the bankruptcy court deemed that they violated the stay and that this suit had to go away.
And so remind me, what was the timing of the lawsuits on that one?
They were
They were
pretty
suing
close
during
in
the
time.
bankruptcy?
Yeah, Peabody emerged April 3rd of this year from them. You know what? I don't know exactly. It was because it was a 2-year process.
Right,
so I'm not sure if the suit came first or if the bankruptcy came first. But the bankruptcy court said that the Chapter 11 completely insulated Peabody from the California lawsuit.
And that just shows how powerful that stay is, though, because as soon as that stay kicks in, do not violate it without the judge's permission. On the opposite side, debtors, trustees, do not use your property without permission from the court. It's a double-edged sword. Everything stops in bankruptcy.
So here's the
Except
question.
for your income.
Yeah.
So your income is
still comes
sliding.
in, but it goes into a separate account that everyone
Right.
gets to see and keep track of.
Right.
So that's when you're talking about businesses, but what about individual? I mean, it seems like the majority of the bankruptcies are with individuals, and how does
They
that
are.
differ from just a normal bankruptcy of a company?
Yeah. Oh, please, Denise.
Well,
go ahead.
I was just going to say that it's different because you have to file a certificate of credit counseling, right? And copy of any debt. You still have the same schedules of assets and liabilities and all that stuff. But in addition to that, you have to have credit counseling. You have to have evidence of payment from the employers. If you have given money to somebody within 60 days before filing, you have to disclose that, and that money sometimes can get recaptured. And you have to have a statement of the monthly net income and any anticipated increase in the income. There's something else too, and I'm forgetting. What is it? It's like some kind of a record of interest. Do you know what?
In what context? Sorry, it's because he covered pretty much most of the bases as far as what people need to
Oh,
provide.
I know what it is. It's a record of any interest the debtor has in federal or state qualified education and tuition accounts.
Yep.
So the 529s, I think, and those type of things.
That, my friends, is titillating.
For all those people in
Rodriguez and
Amargosa
I over
Valley
here, we're
with their 529.
playing Dungeons and Dragons on our computers.
We are having a thumb war during that particular discussion about cram downs and.
You know what's interesting, though, is did I say the word again?
You did.
What is titillating is the fact that this is really, believe it or not, this is important stuff, but it is the most boring stuff in the whole world.
It
But there's a
can be.
lot of people out there that they really need this, and this is really important to them. And it's important to most people.
For people like Dan and I, we kind of find it fun and exciting because there is so much strategy. It's like a chess game in a way because there's just a lot of strategy in the planning. And by the way, we're power partners in that there's a lot of family and bankruptcy crossover. And
Very true.
Yeah, we help each other out a lot when there's the family and bankruptcy questions and crossovers.
What's not entertaining about either keeping or getting money back? What is not fun about money?
Absolutely.
And get rid
I
of
totally
debt.
agree. Let me ask this question. As a civil litigator, I run into this occasionally where I'm going after a business or an individual and they file bankruptcy, and the question is, can we do this or that without violating the automatic stay? What is the sanction if a lawyer or a lawyer's client violates the automatic stay? What happens?
There are generally 2 portions. The bankruptcy court is allowed to impose damages as well as sanctions against the violating party. It's got to be by a noticed motion. You argue it to the bankruptcy judge. You can generally argue whether you actually violated the stay or not. But yes, you can have a damages judgment against you through the bankruptcy court that you will have to pay either to the court, to the debtor. Depends on who the injured party is at that point.
And there is an exception to the stay, too. That's an adversary complaint.
That's
so you can bring, creditors or other interested persons can bring adversary complaints. Back in 2008, there was a major change to the bankruptcy laws. And family law, in California, in family law, their settlements, their judgments, their orders are not dischargeable. They are a non-dischargeable debt. And because of that, initially we didn't know how we're supposed to handle it. And so we didn't know if we bring an adversary action in the bankruptcy court to determine the non-dischargeability, or if we just went ahead and did it in family court. And in California, we determined you just go ahead and do it in family court.
So there's ways, though, that I guess you touched on it, Denise. There's ways that what about the creditors out there? What if they believe that the person's bringing bankruptcy and is hiding stuff? That's an important thing to bring up, Daniel. There's ways I know, and I know enough to get myself in trouble in this area of law because this is not my area, but there's ways that they can try to find that out, or they can take their depositions to find out what's all that about.
Absolutely. That's actually one of the fun parts that I deal with, and one of my main cases right now is we're going after someone for exactly that.
Tell us about it generally. You can't tell the specifics, but generally.
Sure. So, broad background. To answer your question directly, it's called a 2004 exam.
Okay.
And when you have a debtor who says, "Hey, this is all my assets," they give you their petition, their schedules. It says, "This is the real property, personal property, cash that I have." If you have reason to believe, or if you know that they are hiding something, you do a 2004 exam to start building the record. Make them commit perjury, second, third, fourth time on the public record. Then you bring your own evidence and say, "Hey, here's fraud. I have proof that they are lying." You bring in front of a judge. Based on that fraud, you can either, one, have your debt as a creditor declared non-dischargeable. In some circumstances, it depends. But you may get the discharge in the bankruptcy, that big remedy, revoked, so they can no longer use bankruptcy to get that discharge.
And fraud, in this sense, is a higher standard of fraud than just simple fraud. It's like a federal level fraud, right?
Yes. So that's mainly getting into the adversary proceedings. If you have a state court judgment for fraud, it's pretty easy. And in California, they specifically said it's the same elements. But if you have to prove it in court again, like if you don't have that judgment, but you think, there's fraud here, you got to prove it all over again in an adversary proceeding or on a motion to the judge.
Right. Now, what about protecting your house in a bankruptcy? I mean, or creditors going after your house? That's an issue too. There's a Homestead Act. How does that apply, or how does that work? Is there things that you can protect or keep in a bankruptcy? Say, I want to file personal bankruptcy, which is a Chapter 7.
Sure.
What are some things that, no matter what, that are going to be protected and that they can't get? I mean, like, I don't know, my pension. I don't know. What's the deal with that?
Yeah, common things that you can keep. Retirement accounts are in almost every system pretty much fully protected. There's some where it says, well, you can get a reasonable amount of income from your retirement income. And then there's other exemption systems that say, hey, any of it, it's all protected. Real property, especially your home, usually you're not going to give that up unless it's just completely underwater, not worth the hassle to pay everyone off, and you can abandon it and just say, I'm out. Surrendering it. And you just say, I'm done with this. You take it.
What's the homestead exemption amount now for an individual and then for a family?
For an individual, I believe it's $75,000, and then for married, it's about $100,000.
So that means you get to keep that amount of equity.
That amount of equity.
Home.
And if you have a first and a second on the house, and the second impinges on your $100,000 exemption, there are ways that you can have that. Oh, I forgot the legal term for that.
Motion to value, but yes, you can bifurcate the claim.
Yes,
and say
bifurcate means separate.
Like separate, yeah. So
and
instead
actually,
of being
you can
all
avoid
secured,
the lien. You do a motion
depending
to
on the
avoid
timing,
lien.
yes, and you can avoid the lien in some
Cal's got to say something.
Is bifurcating titillating?
No.
I'm just wondering.
No. It's an I don't know.
That's what Cal got out of that segment. He just wants to know if bifurcating is titillating.
It's not bifurcating.
He woke up from laying on the board, but
no, I do have an Amargosa Valley update next hour.
Okay, next hour we got.
that.
Okay, we're on the end of our second hour. We got a third hour coming up. We're about 15 seconds away. We're going to thank Daniel for talking about bankruptcy. We're going to talk about all kinds of fun stuff next hour.
You have been listening to RadioLawTalk.com, a copyrighted presentation of Radio Law Talk Incorporated.